Appellant.
Good morning, Honorable Justices of the Court. My name is Sarah Rashidi. With me today is my colleague Sahra Hashi, and we are both counsel here today on behalf of the appellant, the Crown, in the case at bar. It is the appellant's position that the Supreme Court of Canada erred in finding that sections 11, subsection 1, and 47, subsection A of the British Columbia's Wildlife Act are of no force or effect with respect to the respondent. The appellant has two submissions to make today. First, that Section 35 of the Constitution Act does not protect the rights of Aboriginal peoples located outside of Canada. Second, the respondent cannot establish the continuity element of an Aboriginal individual's right to hunt for ceremonial purposes, which negates his claim. Based on the totality of these submissions, we respectfully request that the Supreme Court of Lions Cup allow the appeal, overturn the lower court's decision, and remit the matter back to the trial court for sentencing. Would your honors require a brief summary of the facts? I will be addressing the first submission, and my colleague will be addressing the final submission. To begin, your honors, I will be walking you through the propulsive analysis of Section 35. This includes the legal lexicon, the historical context, and the contemporary analysis of Section 35 in the case at bar.
Of course, let's talk about historical context. We're going to talk about how there's oppression among the Aboriginal tribes and clans and peoples. There is the deprivation of their lands, their resources, among hundreds of thousands of obstacles that the white man has created for Aboriginal people. Why should the white man create a Section 35 legislation to govern what their rights are? And then we're also going to have Canada determine who is and who is not an Aboriginal person. Why is this right?
Your honors, to that the appellant would submit that the historical context does play a very important role in the implementation of Section 35 with respect to the Aboriginal peoples of Canada. The Crown is understanding of the history that the Indigenous communities have been subjected to. However, the historical context also demonstrates, as agreed to by Inuit representatives and fellow Indian representatives, that the words of Canada do hold a great meaning. That only—
We're not talking about geographic location, we're talking about status, we're talking about identity. So Canada, the white man, is going to now identify who is and who is not an Aboriginal of Canada.
Yes, exactly, because the Canadian government has a sui generis fiduciary obligation to uphold with respect to the Aboriginal people.
The white man took their land from them.
Right.
Why is this okay?
We understand that that is an issue in this context. However, what the matter in the case at bar here is whether the words of Canada can be extended to an Aboriginal group outside of Canada, to which the appellant submits that that's not the case. Because of this, the words of Canada are a clear geographic qualifier that also denote residence. And Nellie Carlson, who is an Inuit representative, has also agreed in the historical drafting of this the Section 35 that it only—
Counsel, I understand the point that you're trying to make, but I just have to piggyback off of my co-judge's, comments. And I think about even the Haudenosaunee people of Southern Ontario, who, they are not only relegated to Southern Ontario, they're located in, New York and parts of the United States, but the Haudenosaunee as a people, they do have rights, just like the Aboriginal rights of the Haudenosaunee here. So how do you now, as I think what our learned judge is trying to ask you, how do we as a colonial court get to decide who is an Aboriginal person of Canada when there's clear evidence that there are Aboriginal people with rights in Canada that are not confined to this geographic boundary?
Thank you for the question, Your Honor. Because As stated in the 2003 Supreme Court of Canada decision of Regina and Powley, the Vanderpeet test that was applied in this situation addresses the scope of the Aboriginal rights, but it doesn't speak to treaty rights, Aboriginal title, or the rights of the Métis, which is also encompassed in Section 35, subsection 1. Therefore, using the test proposed by the courts below to define the Aboriginal peoples of Canada solely in terms of occupation prior to contact is inconsistent with the court's acknowledgement that Section 35, subsection 1 rights may only be exercised by virtue of an individual's ancestrally based membership in the present community. Furthermore, every case must be looked at a case-by-case basis. It's a very fact-specific case. If another group has rights, claimed rights, maybe it's because they satisfy the criterion. In this situation, the appellant submits that the Lakes tribe is not satisfying this criteria.
So your position is that although the Lakes tribe used to be in a Canadian region and then European settlers came in, they forced them out of their land to establish themselves in the Washington area. Because of that criteria and that historical context, now the geographic area is what is more important and continuity cannot be established. And, as a second point to that, I'd like you to address, how does that speak to Canada's efforts for reconciliation?
Your Honors, the historical record thus far shows no sign or attempt of expanding Section 35, subsection 1 rights to non-Canadian Aboriginal groups. The record demonstrates the—
No, that's not the question that I asked. I asked you about the geographic location where the land tribes were forced out of Canada. I want you to address that.
Your Honor, the Lakes tribe was not forced out of Canada. It's clearly in the record, and it indicates that they were not held at gunpoint to leave the territory. Rather, they left at their own will. And because of that, once they became residents of the United States and active participants in that society, the Section 35 rights, which protect the Aboriginal peoples of Canada, including the Inuit, the Indian, Inuit, and Métis, do not apply to them in this situation. And furthermore, if we were to give the words of Canada no importance and no primacy to the Constitution itself, the Constitution Act, this would be exactly what would happen in the courts and what we were warned against as the 2013 Supreme Court of Canada decision of Regina and Blaze. It demonstrates that constitutional provisions that confer rights, they should be interpreted generously, yet they must be contextualized with their original purposes to avoid—
Well, if accuracy was so important, why does it not say in Canada instead of Canada? The last name O'Connor, which is an Irish last name, means of Connor, belonging to a family. You can have O'Connor in various continents of the world. Why don't they establish in Canada?
Your Honors, the appellant submits that when drafting Section 35 of the Constitution, they could have stopped at the words Aboriginal people, period. But
they can also redraft it now, can't they?
Sorry, I didn't understand your question.
They can also redraft the language now, can't they?
Well, they could, as per the living tree principle that is understood. However, that would completely ignore the primacy of the Constitution Act, and it could seriously lead to reaching an erroneous conclusion, which—
Counsel, I'm hearing your submissions, and just in the interest of time, I just want to hear any submissions that you have in terms of reconciliation. And why I ask that is because I'm considering if in your submissions you have considered Indigenous legal orders. And I think about the two Rowampam, which is supposed to signify that, there are two different nations, right? They're independent. And I'm not hearing in your submissions an Indigenous perspective. So I'm wondering if you could speak to that in the time that you have.
Your Honors, to answer your question, the Indigenous perspective must be taken into account in addition with the common law perspective. It cannot be isolated separately because that would defeat the whole purpose of reconciliation with respect to the Aboriginal peoples of Canada and of Canadian residents. Canada's duty in upholding their sui generis fiduciary obligation is to respect the rights of Aboriginal peoples, but as established in by the intention of the drafters of the Constitution, that they cannot reach or invent new obligations, because that would defeat not only the purpose of reconciliation, but it would also bring forth a plethora of other issues, one being inconsistency within the text and within the actions of the state with respect to the Indigenous people. Your Honors, I see I'm running low on time, therefore I will begin my conclusion.
Council, right before you do, but wouldn't you say that at the time of its drafting, that's fine. You can answer this very quickly and give me a very brief conclusion. At the time that it was drafted, weren't those very different times than now, even considering the most recent events of Canada's very dark past with the residential schools?
Your Honor, to answer your question, Section 35, subsection 1 and 2 demonstrate that the framers' intention was not to constitutionalize the rights and relationships of the Indigenous people that arose from prior occupation of Canada by Aboriginal societies, but rather to raise all existing Aboriginal rights in 1982 to constitutional status, irrespective of whether these groups had land before contact or not. Barring any further questions, this concludes the first submission on behalf of the appellant, the Crown, and my colleague will now be addressing the final submission. Thank you.
Thanks, Counsel.
May I proceed? Good morning, honorable justices of this court. My name is Sahara Hashi, and I will be concluding the second and final submission on behalf of the appellant Crown in the case at bar. It is the appellant's second and final submission that the respondent cannot establish the continuity element of his Aboriginal rights claim to hunt for ceremonial purposes.
Absolutely they can, Counsel. They've been doing it for hundreds of years. They established that there was that land for them for hundreds of years. Why are we going to deny them of that because there was a breakage in the timeline?
Your Honors, we ask this honorable court to not side with the respondents due to the fact that the Vanderpeet test must be applied in the case at bar. And the facts in this case do not support or satisfy the criteria of Vanderpeet. Your Honors,
we're concerned that Vanderpeet is inconsistent or not a good test to use. Let me ask you, if it's 70 years in breakage of continuity, is that too long?
Your Honors, it is not about a temporal gap. However, it is due to the fact that Vanderpeet is a binding Supreme Court of Canada decision. Therefore, it's been applied in previous cases. It's been applied in Regina and Sparrow. It's been applied in Regina and the Lax Kw'alaam Indian ban. And in those
what were the time lapses in those cases?
Your Honors, there was no time lapses, but the Supreme Court of Canada noted that the criteria of Vanderpeet were not met, and therefore their claims were not, or they were not allowed. Their claims were not allowed due to the fact that it failed the Vanderpeet test. And it is.
Wouldn't you agree, though, Counsel, that the Lakes tribe had obstacles to overcome that contributed to the breakage of their continuity, the breakage of their ceremonial hunting? And this isn't just their desire to have stopped the hunting. This is being removed from their lands and getting a bright line border of where they can and cannot hunt. Isn't that an obstacle if you're applying this test?
Yes, Your Honor, it is a test, and we would submit to this court that the Vanderpeet test also allows for a holistic understanding of the facts of this case. Your Honors, as the trial judge, we believed erred in applying Vanderpeet, but however, in Vanderpeet, there is a room for it to take into account the Aboriginal perspective alongside the common law perspective. Both must be equally weighed, and one must not be given, one should not be artificially inflated to carry more weight than it can hold. Your Honors, in the case at bar, there is a 70-year gap or 80-year gap between 1930 and 2010. Per the Vanderpeet test, there has to be evidentiary proof that the Lakes tribe maintained an integral connection to their pre-contact practice. And in the case
Counsel, I'm trying to understand the crux of your argument. Is the essence of your argument suggesting that since the establishment of Canada, so that there's a temporal question in the Vanderpeet test, meaning that there is a time consideration in the Vanderpeet test that must be given?
No, Your Honors, there is no time consideration as per paragraph 249 of the Vanderpeet test. However, there has to be proof or evidentiary proof that the practice was integral. In the case at bar, there is the Mr. Desautel provided information that Charlie Quintescant crossed the border to hunt. This cannot tether a claim for continuity as per the Vanderpeet test. Additionally, this one instance, as noted by the dissenting judges in the case at bar, cannot also tether a claim of continuity.
So you're going to exempt this and throw it out the window because there was only one instance? How many instances does there need to be?
Your Honors, we would submit that there has to be evidentiary proof. There has to be more than one instance.
What better evidentiary proof is it than ceremonial hunting? That sounds to me pretty evidentiary.
Your Honors, there has to be a link between the pre-contact practice and the modern day practice. This is where the link was broken. There has to be some form of evidence as highlighted in Vanderpeet between a continuation of the pre-contact practice. Is our submission that this fails at this stage due to the fact that there is no continuation of the pre-contact practice? Furthermore,
I think we're going to go in circles here because I think we're establishing that the Lakes Tribe have gone through many obstacles why they could not have continued their practice. So instead of going there, I wanted to go off, piggyback off my sister Justice's question to your co-counsel. We want you to speak to reconciliation. It's a very, very high regarded factor that we're trying to look into here. How is this decision not going to be forwarding Canada's interest of reconciliation?
Your Honors, the Aboriginal perspective is important. As for the entire section of Section 35 was created with reconciliation in mind. However, we cannot also ignore the common law perspective. We cannot ignore Canada's laws. We cannot ignore the Canadian perspective. Both must be weighed. One must not be given more weight than the other. And in the case at bar, as noted in the binding decision of Vanderpeet, that we have to take into account the Aboriginal perspective, but it should also not be strained in the same breath, I would argue. And as per the 1999 Supreme Court of Canada decision of Regina and Mitchell, there is a boundary that must not be crossed between a sensitive application and a complete abandonment of the rules of evidence. As noted by Justice Beeney, as he then was, in the context of treaty rights, generous rules of interpretation should not be confused with after the fact largesse.
So it sounds like that boundary right that you're talking about, that borderline sounds like an actual geographic borderline. So let me pose you a question. Would it make a difference if Mr. Desautel was standing on US soil and shot a Canadian cow elk standing on Canadian soil? Would this make a difference at all? Because now Mr. Desautel is on US land and he is shooting on Canadian land a cow elk. Is that going to make a difference? Would that be okay?
Your Honors, of course it would make a difference. As per Vanderpeet, every case must be looked at case specifically in the facts of that case. If the facts of this case change and Mr. Desautel could provide evidentiary record of a pre-contact practice and a modern day practice that are strongly linked, then of course, then the courts would have to rule differently. But if the facts of this case do not support a connection between the pre-contact practice and the modern day practice.
Counsel, I know that you and your co-counsel know the law inside and out, you know the facts of this case, but I think that this case speaks to a greater public policy issue. And one of the greatest things that I'm having, the issues that I'm having with your submissions is, you know, you're saying the law is the law and it's the law and it's the law because it's the law. And I think that in the context of reconciliation, we have to be critical of the law. The law is a colonial system. These borders are colonial systems. And who are we to say that these colonial structures are the right structure to determine who is Aboriginal, who is an Aboriginal person of Canada, and who isn't. And I feel as though for your submissions, if you're not able to make some concessions, it weakens your arguments, because we cannot say, there are issues with Vanderpeet. There are issues with the case law. It's not absolute. So I'm looking for you now to tell me what those issues are and how this situation is different, why we should decide this in your favor.
Your Honors, to answer your question, even if this court today concludes that Mr. Vanderpeet, Mr. Desautel is an Aboriginal peoples of Canada, the test would not change. The test does not change between Indigenous groups inside Canada or outside Canada. We submit to this court. So as a matter of that, this test must be applied holistically. It cannot ignore, Your Honors, we cannot separate the common law for Aboriginal law under Canadian sovereignty. The common law must not be ignored, and it must be weighed. To answer Rick's—
I'm sorry, Counsel, but you're ignoring my sister justice's question. The question is, how do we side with you? How do you make the right decision that this is a colonial system? This is not a system that is based on the Aboriginal persons who claim the land first. This is not their system. How do we side with you? How do you make this right?
Your Honors, I see that I'm running low on time. May I have a brief moment to answer your question and then briefly conclude? Your Honors, we understand that the Indigenous perspective is important. We understand that Canada is a colonial state, and Indigenous groups living inside Canada were superimposed a new legal tradition. However, this does not change the facts of this specific case. We're not submitting to this court that if siding with us today does not mean that any Indigenous groups living outside of Canada will not be able to assert Section 35 rights. We're arguing before this court today that this specific case of Mr. Desautel does not satisfy the criteria of the common law perspective. If there was a case where an Indigenous community could provide sufficient evidentiary proof of a reasonable connection or continuity between the pre-contact practice and the modern day practice, we would submit to this court that yes, the courts would have to rule differently. But the facts of this case do not support that assertion. And to conclude, an understanding or a reading of Section 35 we submit would—
Time.
Thank you.
The respondents, who will be the first speaker?
I will be.
Whenever my sister justices are ready, I'm ready as well.
Before I proceed, I would just like to ask the Honorable Justices if you can hear me clearly and if you can see me clearly.
Yep.
Perfect. Good morning, Honorable Justices of the Court. My name is Kay Ferrer, and I'm here today with my co-counsel, William Igbokwe, as counsel for the respondent, Mr. Desautel. We request, respectfully, that the Supreme Court of Lions Cup uphold the lower court's ruling in exempting Mr. Desautel from the Wildlife Act provisions under which he was charged and dismiss the appeal. The respondent has 3 submissions under this request. First, I will submit that Section 35 protects modern-day successors of Aboriginal peoples of Canada, which includes Aboriginal peoples now located outside of Canada. My co-counsel will then submit that a geographical component does not preclude the application of the Vanderpeet test for Aboriginal claimants residing inside and outside of Canada. He will also submit that the trial judge did not err in finding continuity and properly considers the evolutionary element of the Vanderpeet test. Honorable Justices of the Court, this is not a case about a foreign rights holder group asserting their rights in Canada. This is a case that deals with an individual, a person of Indigenous ancestry who is not a Canadian citizen or resident, whether or not he is entitled to exercise his Aboriginal right in his people's ancestral territory in Canada. And I might mention that my friends mentioned that we should take a purposive analysis that follows the logical, and I quote, historical and contemporary context. When we take a look at where the Supreme Court of Canada also mentioned this, they said we should take, and they followed the Queen and Blay, where they said we must take an approach that relies on a proper linguistic, philosophic, and historical interpretation and analysis. You may find this in paragraph 40 of the Supreme Court of Canada decision, if your honors wish to follow. It states that, recall that the charter was not enacted in a vacuum and must therefore be placed in its proper linguistic, philosophic, and historical context, as my friends is asserting today. But I would urge you to look further and note that it states that Justice Dixon was speaking of the charter, but his words apply equally to the task of interpreting the Natural Resource Trades Agreement. In the case of Daniels in Canada, it states that the Constitution is much broader than the NRTAs. The analysis that my friends are proposing today offers a narrow scope into Section 35. We must take into account a completely different interpretive exercise, because the NRTAs and the Charter, while they are constitutional agreements, are not the Constitution itself. We must maintain this purposive analysis that utilizes a manner in which the Constitution is interpreted.
So if we want to maintain a purpose of analysis, then I think that the drafters of the legislation would be very, very specific with how they wanted it to be worded. There's a reason why they mentioned of Canada, and they didn't mention specific every single tribe either, right? If we're going to be taking your approach, then what we're going to be doing is affording a US citizen double protection under two different legislations. We're going to be looking at them in the perspective of Canadian legislation as well as US legislation. It's difficult to establish that this US citizen has a constitutional Canadian right.
Respectfully, Your Honor, he would not be having a double protection. Mr. Desautel is a member of the Lakes tribe who is a modern-day successor of the Sinixt people. The Sinixt people were here for thousands of years before Europeans came into Canada. They are rightly more Canadian than we are because they were here before the colonizers came and imposed their laws and regulations and systems upon the Aboriginal people. So we would not be applying a double standard because Mr. Desautel is a Canadian under the phrase Aboriginals of Canada. Aboriginals of Canada were here before Canadians, before Europeans were here.
But the break in continuity is what's concerning here. I understand, and I'll take the position that there are obstacles that these Aboriginal tribes and lands have faced, but the break in continuity is quite concerning. There needs to be a better remedy to asphyxiate for your position.
Honorable Justice, in terms of a break in continuity, Mr. Desautel, as a member of an Aboriginal group, continuously hunts and practices. And we should allow him to do that in these lands. As we take a look here today, there are many different people in our courtroom, and Canada prides itself on being a mosaic. There's a lot of different people from different parts of the world who come here and enjoy our land. Aboriginals are a core group in that. They are people, yes.
I understand where you're going with your arguments, and I would just urge you to consider, colonial legislation, like for instance, the Indian Act, that says and that dictates who is considered Indian and has Section 35 protections under the Constitution. And if we think about legislation such as the Indian Act, there are people that are excluded from the protections of being Indian under the law. Are been, and some of the implications are, you cannot live on reserve with your family. You don't have that protection. You don't have that relationship to your band, right? Because of colonial laws. And if we were to accept your submissions and rule in your favor, what do we say to those displaced Indigenous people in Canada that because of colonial laws have excluded them from their own identity? And we say now this man, Mr. Desautel, that is a US citizen, now has Aboriginal rights here.
Respectfully, Justice Dyer, I apologize if I mispronounced that. With the idea of the colonial laws and the Indian laws, if we were to allow the appellant submission today, we would be imposing and enhancing the colonial system in such a way that we are allowing Canada, the white man, to assert its rights and dictate who is Aboriginal. And if we were to allow Mr. Desautel to seek refuge in Section 35, then we would allow him to be Aboriginal. As I've mentioned before, he and his group are a successor of the Snakes people who were here thousands of years before any of us were here.
Counsel, do you know how many times a year or how many cow elk Mr. Desautel shoots per year?
No, respectfully, no, Your Honor. I don't have the exact number. He did just shoot
because
the one.
I'm just concerned because there would be a huge difference if, you know, this is something that he did every season, or if he just decided to cross the border on one given day and said, I'm going to hunt, and with no real intention behind it. And now he's charged under the Wildlife Act and says, how am I going to find a way out of this? I know it's a you know, a harsh perspective to take, but what stops other people from doing the same thing?
Your Honor, Mr. Desautel was not crossing a border. He was passing through his ancestral territory. Aboriginals do not see land in terms of borders or difference. This is his ancestral territory, the area from—
But the Canadian sovereignty does, and we do owe deference to them.
Yes, Your Honor, we do owe deference in the purposes that Section 35 has the two main purposes, and that's where we must guide and utilize for deference. In the idea that Section 35 has the purposes of reconciliation and
Counsel,
recognition.
Can I just ask one question? Do you know if he was hunting for himself or for a community basis?
Mr. Desautel was hunting and exercising his right to hunt for ceremonial purposes. Aboriginals in nature are communal, so he would be hunting not only for himself, but also for his community.
So it was not for sport. You're just clarifying.
Yes, Your Honor. No, no, Your Honor. It was not for sport. If it was for sport, it would be a completely different issue that would have lots of other implications. However, in this case, Mr. Desautel is exercising his Aboriginal right to hunt for ceremonial purposes.
I'll take that position, but I believe that my sister Justice Sayers, her concern is that he was hunting for sport and can't just say that he has Aboriginal background. This leads to a slippery slope of perhaps citizens who are not honest and not candid.
Your Honor, in terms of if Mr. Desautel was hunting for sport, if he was hunting for sport, it would be a completely different matter. However, in this case, we are looking at it as the fact that he is an Aboriginal member of the Lakes Tribe group who is his modern day successor of the Snakes people.
Can you give me a brief conclusion and you pass it on to your co-counsel?
Yes, Your Honor. In conclusion, to limit Section 35 rights would run counter to the Crown's ability to maintain the purposes of Section 35, which is to uphold reconciliation and recognition. Barring any further questions, I will now yield the podium to my co-counsel. Thank you.
Thanks, counsel. I'm already empty. I thought it would last me at least one round. I think I said yesterday, the more coffee I have, the more questions I ask. So this is only one cup. Okay, I am ready.
Are the judges able to hear me correctly?
Yeah, you sound good.
Good afternoon, honorable justices of the court, and good afternoon, my friends. My name is William Iboki, and I'll be concluding the submissions on behalf of the respondent, Mr. Desautel. Your Honors, I'm submitting that a geographical component does not preclude the application of the Vanderpeet test, and thus the claimants residing outside of Canada. And next, I'll submit that in applying the Vanderpeet test to the claimant, the trial judge did not err in applying such test, as she properly framed the continuity principle in consideration of the evolutionary element.
All right, counsel, let's say I take your position and that Section 35 can apply to persons, Aboriginal people outside of Canada. What stops European Aboriginals from making claims on Canadian lands? If there's historical and contextual connection, if there's a nexus to Canada, what stops people from Europe, people from Asia, people from South America making claims onto Canadian land?
Justice, you bring up a very good point, especially in relation to geography. However, firstly, I'd like to reframe respectively that Aboriginals from Europe, from Australia are they're not European, they're not Australian. So in that context, when they're trying to prove their Aboriginal rights, they're trying to prove such rights as connected to their traditional land. So we should not, in this case, as you're putting it, look at it as Europeans coming into Canadian sovereignty. We should look at it as Aboriginals coming back to their traditional land.
So
theoretically,
I just want to clarify. I'm going to take your argument. I do like it, actually. You're saying that European Aboriginals are actually to be considered as Canadian Aboriginals living in Europe.
Your Honor, we submit that not necessarily in that case. I may have rephrased it incorrectly. They may be residing in Europe.
I liked it the first time, actually, because it sounded like a pretty strong argument. But this still leads to a slippery slope, because if we're going to take your position, then it sounds like on this event over here, Mr. Desautel is trying to win on a technicality. The proximity, the actual distance in the distance between between Canada and the American border is very, very short from each other. And that could be the technicality. So that's why we're concerned about geographic location. But where does that distance become a factor?
Well, Your Honor, that distance solely becomes a factor after the application of the Vanderpeet test. As the court in Mitchell stated, geographical considerations are to be considered as per the Vanderpeet test, the extent to which they apply to the claim. So as per jurisprudence, it will be incorrect to use the geographical consideration to apply it or to somehow preclude the application of the Vanderpeet test, even though the jurisprudence has stated specifically that it is through the test itself, it is through the Aboriginal claims themselves that allow us to understand the extent to which geography plays a role. And geography is a very critical reason as to why, is because colonizations, because we got to understand particularly the concept of displacement.
Sorry, Counsel, I'm confused. Are you telling me that geography is a strong factor or is not a strong factor to be considered?
It's only a strong factor in the sense of when you're considering particularly the concept of displacement. When you're considering the concept of displacement, especially in this case, when we take a look at the facts, the first stage of the test, the claim states that Mr. Desautel wants to go into his traditional land, the northern region, and hunts for ceremonial purposes, which the court does not, according to my knowledge, does not disagree with. According to the second stage of the test, it is not only integral, it was not only a practice to his pre-contact society, it was integral to his pre-contact society. And then as per the third stage of the test, we submit that it's a continuation, and that although that he's a United States citizen, even though we submit that that is not the case here, he has provided evidence that such a practice has continued on up until this day.
I have two questions for you to define. Can you define what is meant by continuation? And then once you answer that, I'll ask you another question.
Absolutely, Justice. We submit that continuation refers to the continuation of a pre-contact a practice that was integral to the pre-contact practice. And as such, that continuation demonstrates that it's also integral, not only in terms of substance, as my friends may frame.
If it were so integral, though, why didn't they practice it more often? Why was there such a gap in the length of time?
Well, Your Honor, taking a look at, in fact, this actually takes us to our second submission, because Justice Cote looks at the 1930 onward interruption as she uses this to forfeit the claimant's assertion that it's an inadequate representation of the pre-contact society. However, when you take into consideration the evolutionary principle and consider the instance of colonization, how that might have affected the growth of the practice, such a notion becomes to light. And if I may draw your attention to paragraph 48 of the
But this could have happened in 1940, this could have happened in 1950, 1960, but we're dealing with it in this year. There's nothing that explicitly stopped Mr. Desautel. I mean, perhaps prior to when he was able to have a license for hunting, or before he was born, or anything like that. But was there anything explicitly stopped him or the Lakes tribe from doing it between that period of time, explicitly?
Mm-hmm. Absolutely, Your Honor. As the court in Mitchell stated, Chief Justice McLaughlin stated specifically that along with the practice, its associated cues must be allowed to evolve. This particularly points to the external and internal factors of the practice. So when we take a look at the external factors, we submit that the colonization, particularly as stated by the trial judge, the international treaties and subgovernmental treaties that were laid on that hindered the practices of the claimants. And we do submit that although it did not stop the claimants it did not directly lead to the 1930s ceasement or interruption. However, the trial judge still noted that there was a gradual decrease in such practices. We submit that it would only make sense that as international boundaries and subgovernmental boundaries grew stronger, cross-border hunting would only slow down. And that is only just the external factors. When you consider the internal factors.
I'm curious to know, and I see where your arguments are going. And Mr. Desautel has a connection to his community. He's practicing, hunting ceremoniously for ceremonial purposes. I want to know from your submissions, if there's anything that I've missed, what is so unique about this particular tract of land to his community that is not significant in Washington, D.C.?
Mm-hmm.
Absolutely, Your Honor. To that statement, I think we should remain consciously aware, as was stated in the evidence, that was a land that remained in their minds. There's many examples of this throughout all of history. The main one, for example, is the slavery of slaves that came across the boats. You can only imagine that they only remembered that the land that they were taken away from. We must pay close awareness to this sort of oral history, as the court in Delgumuk stated, that there must be great importance placed on the oral history. Aboriginals throughout their lifetime have not their history, they did not develop information or track information the same way Europeans do. And as thus, we should not understand it the same way. And in light of that, the reason why they maintain such a connection to that is we submit that it's plain and simple. Through the instance of colonization, they were displaced and they're just looking to come back.
So I heard one answer that's oral histories, as in Delgumuk, which is, that case stands for, oral history. Can you tell me about what he was hunting? Is what he's hunting different from what he would hunt in Washington, D.C.? Because these are considerations, and we're not only taking in the common law, but we're taking an Indigenous perspective. What about this land, what's specific about this land that is unique, that is different from the land that he is a resident by national law?
Well, the first instance of why it's significant is because it's their traditional territory. This is the territory that they've lived on for centuries. And after they have neglected from living on and hunting on their territory, following the instance of colonization, we submit that it only makes sense to go back and to exercise their rights that they've been exercising for thousands of years prior to it being taken away from them. In light of the time, I yield the podium to the judges. Thank you.
Counsel, I have another question for you. I want you to answer this briefly. You don't need to do a conclusion. I just want you to answer my question. There's a very slippery slope that we're looking at in various routes. If it's either in common law, if it's in the Constitution, if it's policy, that there's a lot of different risks that come with taking your position on this, as there are risks with the other side taking their position on it. But the one thing that I want you to note, and if you can comment on it, if we're going to take your position and afford Section 35 rights to non-Canadian citizens, non-Canadian Aboriginals, does the Crown still owe a duty to consult?
We submit, Your Honor, that absolutely, that the Crown still owes a duty to consult. As stated in the Haida case, I believe at paragraph 32, consultation is part of a fair process towards reconciliation. And as further stated, I believe in the Powley decision, as my friends may mention, it may raise some difficulties. However, the court specifically stated that such difficulties in itself should not be exaggerated to a point that leads to the claimant's claim being forfeited.
Thanks, Counsel. That's sufficient. Guys, fantastic job. You all hung in there.